A sponsor has a real estate deal and three friends willing to bring passive capital. The sponsor asks, can we call this one of our real estate joint ventures instead of a Regulation D real estate syndication? This is syndication attorney Field Notes with Tilden Moschetti. I'm Tilden Moschetti, a syndication attorney. Today's Field Note is about when a sponsor capital raise moves from a joint venture into a securities offering. The short answer is this. The label on the document does not control the outcome. What the partners actually do controls the outcome. If the capital partners are active, skilled, and truly helping steer the project, a real estate joint venture may fit. If they are writing checks and relying on the sponsor's efforts for profit, the deal may need to be treated like a securities offering. If no exemption was used, that can become a potential unregistered securities offering. The mistake I keep seeing is treating a joint venture as a budget choice. A real estate joint venture is a legal classification, not a budget decision. The thinking usually sounds like this. We only have three investors. They know us. They are high net worth friends, and everyone is signing a JV agreement. So securities laws are off the table. That is not how the analysis works. The number of investors does not settle the issue. The title on the agreement does not settle the issue. Even the word partner does not settle the issue. The better question is, who is doing the work and who is depending on whom? A true joint venture is built around active participation. Everyone has a real role. Everyone brings useful knowledge. Everyone has practical power to affect the project. Think of two experienced developers teaming up on one deal. One handles land acquisition and entitlements. The other handles construction and leasing. Both know the business. Both make real decisions. Both can step in if something goes wrong. That is much closer to a true real estate joint venture. In that kind of deal, state contract law is usually the main frame. Passive capital is different. If investors put money into a common deal and expect the sponsor to create the profit, you are now in securities law territory. The Howey test is the common frame for that. In plain English, it asks whether someone put money into a shared venture and expected profit, mainly from someone else's efforts. That is the investment contract idea. It is not about magic words. It is about economic reality. Now take the common apartment example. The sponsor finds the apartment building. The sponsor negotiates the purchase contract. The sponsor works with the lender. The sponsor manages the renovation plan. The sponsor handles leasing, reporting, refinancing, and the sale decision. Three friends put in the equity. They get updates. They may have a vote on a few major decisions, but they are not running the project. They do not have real estate operating experience. They have day jobs. Their real role is writing the check and waiting for distributions. Calling those people capital partners may describe the money. It does not prove active control. That arrangement looks much more like passive capital in a sponsor capital raise than a true joint venture. This is where paper voting rights can mislead people. A sponsor might say each investor gets a vote on major decisions. They can approve a sale, they can approve a refinance, maybe they can even vote to remove the manager. Those rights matter, but they do not end the analysis. Paper voting rights are not the same as practical power. Practical power means the investor can understand the issue, has time to act, and can actually help run or change the project. If a busy surgeon invests in a real estate development, a vote on construction draws may not mean much. The surgeon may have capital. The surgeon may be smart, but that does not make the surgeon a developer. So if the sponsor is still the only person with the knowledge, the time, the team, and the authority to move the project, the investors may still be passive. Now flip the facts. Two construction firms form an LLC for one subdivision. One firm brings the land pipeline and entitlement team. The other brings the construction crew, project manager, and local subcontractor network. Both firms attend project meetings. Both approve budgets. Both take on real tasks. Both can affect the outcome through their own work. That looks much more like an active joint venture. Same word, very different facts. That is why a joint venture is not a syndication light. There are a few assumptions sponsors should be careful with. Do not assume a small investor count solves the issue. 3 passive investors are still passive investors. Do not assume an LLC operating agreement solves it. Forming an LLC is an entity step. Selling membership interest to passive investors is a securities step. Do not assume the term capital partner solves it. It may describe who brings money. It does not prove who controls the enterprise. Do not assume limited partner interests are interchangeable with active JV interests. By design, a limited partner is not running the business. That points toward a passive investment role. And do not assume the lender will see this as only a paperwork issue. In a commercial lender review, bank counsel may ask how the equity was raised. If the capital stack looks unclear, the loan process can slow down when timing matters. There can also be investor refund claim questions if the deal was really a securities offering but was not structured with a valid exemption. That is not the focus of today's note, but it is one reason this classification matters before money comes in. The clean way to think about it is not, what can we call this? The clean way to think about it is, who is actually steering the project? If every person is active, expert, and in practical control, a joint venture may fit. If the return depends on the sponsor's work and the others are mainly supplying passive capital, then the deal belongs in Regulation D securities offering analysis. Final field note, ask who is actually steering the ship and who is just along for the ride. The answer to that question, not the title page, decides which set of rules you are dealing with. The longer written version is in the show notes.